Hi guys, Alena Shautsova, immigration attorney from USCIS here. Today we're going to have our live about the most recent immigration news. I'm going to discuss with you EB2 visibility and retrogression. What happens when it happens? What can you expect? What can you do if, for example, you adjusted but your family members did not receive their green cards? We're going to discuss some recent USCIS policy changes, and of course, I'm going to answer your questions, answers, whatever you would like to ask me. So thank you very much for joining me. Let's wait for a little bit more people to join, and we're going to start. All right. So, hi guys, don't forget to tell me where you're watching from. Hi Pimby, hi Peter, hi Abhi, hi Michael. Nice to see you all, guys. It's been an interesting month. It's been an interesting month for those of you who are waiting for your employment visa categories, especially for those of you who are from India. You know that the wait time for employment-based categories for India or for some countries are ridiculous, like ridiculous. And of course, every month, in the end of the month, we're waiting for that visa bulletin to see what's going to happen. What is it going to show us? How it's going to be? Is it going to be a good month for those who are in the backlog for employment-based visas or not? And I'm going to tell you this. This particular month has not been so good. EB2 for India retrogressed for about 2 years back. Devastating, especially for those who were planning on adjusting status and perhaps already filed I-45s. And sometimes you even going for that interview and you're going to be waiting for a decision by USCIS officer. But guess what? Once your category retrogresses, you will not be able to get that adjustment approved. It's very interesting because in case it will get erroneously approved, later you will not have your naturalization approved. So it's very frustrating sometimes to deal with the preference categories. Preference categories are categories where, in addition to the processing times, you also have to deal with line of people who are in front of you. And in this particular case, we're dealing with EB2 India retrogression that happened in October 2022. So what happens if you, for example, the primary or principal applicant, you were able to get your green card and your family members were not? By the way, this idea is relevant not only for people from India, but for other retrogressions as well. Sometimes we see retrogressions in family-based categories. Luckily, not now, but sometimes we do. And what happens sometimes is that people going to file for adjustment of status based on the current category, current preference time, but by the time they reach the adjustment of status interview, or by the time the decision must be made, the visa category is going to retrogress, and the person will not be able to get that adjustment done. So do not despair. If you, as a principal, got your adjustment, but your dependent eligible family members did not, you may have an option of filing for them a family-based petition, which it's F2A petition, which should be current, okay? Of course, the problem with the family-based petitions is that if you would like to get green card in the United States, you have to demonstrate that you maintained lawful non-immigrant status throughout your stay in the United States. This is true not only for spouses of green card holders who are sponsoring their spouses or children, but also, for example, and this is where a lot of confusion coming from, It's also true for, let's say, if a parent would like to sponsor an adult, married or unmarried son or daughter. If we're talking about a parent who is U.S. citizen, or if a parent who is a green card holder is sponsoring unmarried son or daughter, that son or daughter will have to show that they maintained lawful non-immigrant status throughout their stay in the United States. And if this is true, then you can file for adjustment of status for them based on a family-based category. Sometimes your family members already filed for adjustment of status, perhaps as dependents on your employment-based petition, but their petitions were not decided yet. As long as they maintain their lawful non-immigrant status prior to filing for their I-45 green card application, now you can still show that they are in status because you will not be filing new I-45, but rather you're going to ask that USCIS is going to change the basis for the adjustment of status from that dependent employment basis that they had to family basis adjustment of status. It's called interfiling, very important. So it also happens sometimes with I-360, I-130 petitions, guys. If you filed I-130 and I-45, I-130 was filed for you by your spouse, marriage did not work out, and now you're going to go for VAWA I-360. It may be good for you sometimes if you would like to save $1,225 rather than paying and filing for new I-45. You're going to ask USCIS to switch the basis for adjustment from that I-130 that was filed to now I-360. There's its own pluses and minuses here because you have to keep mindful. If your I-130 from that failed marriage will be withdrawn, for example, prior to refiling and informing USCIS that you would like to change the basis for adjustment of status, you may lose employment authorization that was given based on I-45 filed with I-130. So I usually recommend clients to refile the entire package, but again, it may be an option. So remember, it's called interfiling, when you're asking USCIS to change the basis for adjustment of status, right? From one basis, be it I-130, I-360, I-140 to I-130 to another. Now, what if you failed to maintain lawful non-immigrant status? What if your I-45 was denied and you did not accumulate enough unlawful presence to make you inadmissible? Then you may choose consular processing once basis for your green card or immigrant visa is approved. So as you see, it's complicated sometimes to decide which route to choose when visa retrogresses, visa bulletin retrogresses. You sometimes have to make strategic decisions as well. What if you lose your employment authorization based on a pending I-45 because you're switching cases and so on and so forth? It's always recommended to speak with an attorney when you do so, just so you will know what to expect, what your risks are, and if you're willing to accept those risks. Extremely, extremely important. Another little news I wanted to share with you would be concerning USCIS policies. You may know that USCIS is going to now give extension, automatic extension, to those people who are renewing their green cards. I'm not talking about 2-year conditional green cards. I'm talking about regular green cards that are expiring. And when you need to renew it now, you're going to get automatic renewal, not for 1 year, but for 2 years. Well, why do you think it's such a change? Well, nothing good, actually. The change comes from the fact that there are tremendously long processing times to renew your to file your I-90 form, renewal or replacement of your green card. You have to keep it in mind. For example, you may receive your green card with a mistake on it. Let's say it says that you're male versus female. There was misunderstanding, or there is an incorrect name, slightly misspelled name, keep in mind that if you're going to ask for the card to be replaced, it will take you a very long time to receive it. So sometimes, in the case of male versus female, for example, sounds sometimes strange, but people choose not to change their green cards despite of the obvious mistake, not to be left without the green card. And they don't experience any issues actually at the border or when they go for that naturalization afterwards. So something to keep in mind when you are dealing with extensions for your green cards. All right, and finally, a little bit about immigration reform and where we stand with that now. Guys, not much news here. I do receive inquiries every now and then as to what's happening, what's going on. The latest news that I received, and you probably did too, would concern DACA or Dreamers. And the news is such, it's not looking good apparently in the United States Supreme Court for DACA holders. DACA may be canceled altogether. We do not know what exactly is going to happen, but we know one thing, that for the DACA holders to have the safety net and to have safety for the future in the United States, Congress must pass the law. We had several proposals coming from both Democrats and Republicans with regard to the Dreamers. None of them actually resulted in a law itself. But hopefully, before the November elections, something will be talked about again, something fruitful. So far, what I read is that the Biden administration is considering executive action with regard to the DACA or Dreamers, which probably will be very limited, which probably will concern only policies regarding the deportation or removal practices. Well, it's something within the control of the executive branch. So we're going to see what's going to happen. I don't think it's going to be a new status that's going to be given to DACA holders, because immediately it's going to be a target for the challenge in the courts. I think that maximum what it can be is that restriction on physical removal, and we're going to see how it's going to play out. So if you are a DACA holder, please make sure, number one, you do file for the renewal timely. Number two, you do not leave the United States without advance parole being granted. Extremely important. And of course, you have to pay your taxes. We're going to see if the law will be passed for you guys, and if it will. Every single proposal that I've seen so far includes a requirement that you have to show you've been paying taxes in the United States. Very, very important, very important. So we're going to see what exactly is going to happen with that, how it's going to happen. I do hope that they will pass something for the DACA holders, but I don't know. I don't know. Let me know what you think. Let me know what you think. For now, please get ready with your questions. I'll be very happy to answer them. All right. So let me see if we have any questions, answers. Hi, Peter. Hi, Michael. Watching from Connecticut. Yay. Oh, DV Lottery. Somebody's asking about DV Lottery. Yes, guys. In 2 days, DV Lottery starts. Do not miss. You're going to go to the official website of Department of State to do that, to submit your inquiry. Make sure that you read instructions for the submission of the inquiry. Make sure you provide correct information. If you have several names, official names, make sure that you put them in that inquiry exactly as they appear in your passport. Extremely, extremely important, okay? Children, all children must be listed. Those who may qualify potentially for a green card, meaning stepchildren, adopted children, children that change their names perhaps for whatever reason, who are under 21. Extremely important. All right, let's see. Hi, Collins. Please, is there anything I can do to get an interview date for asylum? I applied since 2019, but it says case not found in the system. Well, first of all, you should know that asylum cases are rarely found in the system due to confidentiality. It's very interesting how the system works. Sometimes you really can see some progress using online status, and sometimes you cannot. What you need to worry about is this: have you received a receipt for your asylum filing? If you have, your case definitely was filed. Can you speed it up? I'm going to tell you, Mr. Collins, that people are going to be really upset because you filed your case in 2019, and some people who filed their cases in 2016 are still waiting for their interview. But if you must expedite your interview, you may do it by two ways, basically. Way number one, you can ask the case to be expedited if you have a good reason for it. You can submit your request to expedite your asylum filing. That's number one. And number two, to sue USCIS. There is a special lawsuit that may force the government, which I don't recommend usually, to give you that interview. It's a possibility. So you may choose with your attorney which one will be better for you. All right. Hi, Rizar. How long do I have to wait after my case has been approved? I'm not sure what kind of case was approved and where you are at. If you're overseas and your case was approved and it's a marriage-based case, usually within 60 to 90 days after the approval, you're going to receive a notification from the National Visa Center inviting you to pay the fees, submit certain forms, submit application, DS-260, and so on and so forth. If you're in the United States and your case was approved, if your I-45 was approved, then within 2 weeks you should be receiving your green card, right? It depends on what happened, what's been approved. So that's what needs to happen. But if you give me some more information, maybe I'll give you a better answer. Hi, Rohan. Hi, can I adjust my status if I came on a C1 visa? Usually not. Usually not. A person who comes on a C1D visa is ineligible for adjustment of status in the United States. You also will not be able to change that visa to anything else. There is pretty much only one option for people who came in on such a visa. It only applies to those who may qualify for asylum. If somebody entered the United States on C1D and successfully filed for asylum, later they will be able to adjust their status and receive a green card. Hi, True Wisdom. Do you know processing time outside the country for I-130? It depends on who you guys filed that I-130 for. If this is for a spouse, usually I-130s for a spouse would be approved, the petition itself, in about 9 months. If it's for a parent, we're looking at 3 to 5 months, much faster. If it's for a sibling, the processing times, I'm not even talking about the preference category wait times, is going to be much longer. Perhaps it is because USCIS knows that the preference category is going to take much longer to result in ability for you to file for a visa. So it's going to take much longer than that, sometimes a couple of years. Hi, Lila. I have a J1 visa, stayed only 1 year, and I came back to the United States. I want to do waiver based to adjust status, but my embassy don't, okay, your government does not give you a no-objection letter. What can you do? Then there are other grounds for the waiver that may apply to you. The first ground would be that very similar to asylum, that you cannot go back to your home country due to certain dangers that you may face there. And a second ground is extreme hardship to your relative. You will have to have a relative. So it depends on, of course, there may be some other grounds, perhaps, But if you say that no objection letter was not given to you and you didn't serve your 2-year foreign residency requirement, that's the question, right? What can you do? So usually people are going to go for the hardship waiver if you're adjusting status based on a family petition, all right? So that's initial points for you to research. If you would like to consult with us, I'll be very happy to do so. Hi, Tasha. What usually happens when USCIS gives you all priority on your I-45 new application priority date is from I-130 family based? Well, priority date is being calculated based on why you're adjusting your status, right? So that's what it is. I-130 usually has either will not have a priority date or always current priority date for immediate relatives, or it's going to have a priority date depending on the category. So I'm not really sure what you mean by it gives you an old form I-130 family based. If it's a preference based adjustment of status, you will have to use that priority date from that I-130 that was filed previously. There is no option really, right? And then you will have to show that you maintain your lawful non-immigrant status, something that we talked about at the beginning throughout your stay in the United States. If we're talking about adjusting status based on a preference-based category in the family immigration, right? But if I get some more information from you, maybe I will understand the question a little bit better. Hi, Mohammed. Aha. Okay, hi, Tasha. My priority date is from 2019. Now file I-45 this year. Priority date on my receipt is 2019. Okay, so perhaps that's correct. I need to see the file and see what's going on, right? So not sure what happened there. As I said, if it's a preference-based case, then it's fine. I mean, and for immigrant and for immediate relatives, if it is your U.S. citizen spouse who's filing for you, the priority date doesn't matter. Sometimes it's still printed on your receipt as a priority date, but it doesn't really have any meaning. What is meaningful here is exactly the I-130 priority date or I-140 priority date in preference categories, guys. Because priority date as a as a character, as something that's of importance, only plays any role in preference-based cases. But I've noticed that there are receipts for non-preference-based cases where they still publish priority date, but it doesn't matter. Hi, Mia. I'm a green card holder and it's going to expire in 2023. Should I renew my green card to apply for citizenship? Great question. Tell me, why would you not file for your citizenship? Well, first of all, under the rules, if your green card is expiring within the 6 months, you must file for it extension, for the extension of the green card, even if you're filing for the naturalization. But if your question is, should I just continue my green card or shall I file for naturalization? Usually the answer will be, of course you should file for naturalization, okay? Naturalization is way better than the green card, citizenship. Why? You cannot be deported. You will be able to vote. You will be able to serve on the jury. Guess what? You're going to get American passport and travel without a visa to many countries in the world. That's a benefit. So, and sometimes, by the way, you will be able to sponsor certain family members as well, such as your parents. You cannot sponsor your parents, guys, while you're still a green card holders. So those are the benefits of naturalization. So absolutely file for naturalization. Who will not file for naturalization? Well, if you did not rather maintain continuous physical presence in the United States necessary to file for naturalization, or you have certain arrests that you're dealing with, probably you will wait to resolve them, right? Or perhaps there was a denial in the past for some reason, and then you have to wait for those 5 years to pass to refile due to a good moral character or problems, then you will wait. Otherwise, file for naturalization. All right, guys, so this is what I wanted to share with you today. I hope you find this information helpful. If so, please like and share this show. I'll be very grateful to you. I'm always very grateful to you, by the way, always, that you're helping me to grow my channel, grow my social network, grow my presence. Because of you, I'm here. Because of you, we're having these videos. Because of you, I take my time to help you guys out, to answer questions for free, because I do enjoy that. And again, thank you very much for all of you guys' help, all of your involvement. You're like my social media family. So I hope you find this information helpful. If you do, please like and share this stream, and don't forget to stay in touch. So next week we're going to see each other again and discuss more interesting immigration problems. Thank you very much, and I hope to see you soon.